The broadcast is now starting. All attendees are in listen-only mode.
Thank you for joining me today for this webinar on the UK immigration system post-Brexit. I've done a number of talks this week and recently about Brexit and immigration and all of the policy changes, etc. I thought it would be a good idea to record them as a webinar so that those of you who haven't been able to come to listen to me in person are able to pick up all of the information. Just about me, I'm the managing partner at McGrath Sheldrick. We're a specialist law firm. We focus on immigration and employment law. We have done for 30 years. In fact, we're celebrating our 30th anniversary this year, and we're recognised in all of the major directories as leaders in our field in terms of immigration law. What am I going to talk about today? Well, the agenda is around the transition this year. It's a pivotal year for immigration. It's the transitional year between the agreement that was reached with the European Union for our withdrawal from the EU at the end of last year, and of course the political settlement in the UK, where we have finally got to a position where our politicians have agreed the way forward and passed the necessary legislation. And that means that we're in a transitional phase up to the end of this year, and it'll be the 1st of January 2021, which I think of as the sort of real Brexit day, when we'll start to notice very quickly significant changes in respect of our relationship with the outside world, and most importantly, of course, as far as I'm concerned at least, in respect of immigration rules and procedures, etc. I'll also talk a little bit about the outlook for an agreement with the EU in 2021. Those conversations have started to take place, and I'll make some reference to whether or not I think that there will be any form of mobility provision in a future trade agreement with the European Union. I'll touch also on protecting citizens' rights. Obviously, that's been an absolutely crucial piece of the jigsaw in determining the way forward in the Brexit context. Most of you will be familiar, I think, with the EU settlement scheme and the provisions in respect of EU citizens currently living in the UK, but we'll do a little bit of revision on that. And then most importantly, I'll talk about the new framework for UK immigration control. That's the real headline at the moment, as I'm recording this at the beginning of March 2020. There was an announcement, a policy document was issued a couple of weeks ago by the Home Secretary, which sets out the framework for how she sees the new immigration scheme in the future. And I'll talk about that and make some reflections on it. And it's based around a points-based system. Many of you, of course, know that we already have a points-based system in the UK, but I'll talk about how it's going to differ in the future. So Transition 2020, we voted to leave or the country voted to leave the European Union in 2016, so that's nearly 4 years ago. And over that time, I've been to countless seminars, I've spoken at lots of events, I've been to lots of events. Obviously, there's been endless discussion in the media around the topic of Brexit, but this is really the first time now, after all of this passage of time, that we really have a clue about where we're going next. And that is because there has been a political settlement in the UK. The general election in December was a defining point in this scenario, because up until then, the political position had been incredibly complicated, difficult, toxic. Parliament was at war with itself, as I'm sure you all know, and the previous government didn't have a majority, which made it impossible for the former Prime Minister, Theresa May, to get her version of Brexit through the House of Commons and to pass the necessary legislation, which is the European Union Withdrawal Agreement Bill. That has now been passed, and the new government, which is a government led by individuals who previously led the referendum campaign, so their position on Brexit is very well known. The new government has a significant majority, and that means that we have passed the point of no return now, because on the 31st of January, legally at least, we left the European Union. Now, That's the legal position, because up until that date it would have been possible, in theory at least, to revoke Article 50 and to potentially have another referendum or go for a different type of deal with the European Union. There are various versions of Brexit that have been discussed over time, including a soft landing into the European Economic Area, or a hard Brexit, no deal type scenario. All different routes have been open, but now the position is much clearer. And on the 31st of January, legally, we left, and politically, the matter has now been resolved. But the next 10 months are crucial, because it's during this period that we will negotiate our future relationship with the European Union. And also, it's during this transition or implementation phase that we have to prepare for the end of free movement. Free movement does what it says on the tin. It means that members or citizens of countries from EU member states can travel freely between member states, and they can work, they can retire, they can set themselves up in business, they can really operate in exactly the same way that they can in their home country. And British citizens have benefited from that arrangement for a number of decades. And that's why 2021, 1st of January, will be a seismic change for British citizens, because that's when freedom of movement will disappear. And that's the legislation has already been introduced. In fact, it's been introduced this week in an Immigration Bill 2020 that will legislate for the end of free movement. The end of free movement, I suppose, is inevitable, given our departure from the European Union, given the discussion around immigration during the referendum campaign, given the fact that the government is led by the Brexiteers. It's inevitable that free movement will have to fall away, and we'll have a new arrangement for immigration control for both EU and non-EU nationals in the future. In terms of our relationship with the EU in the future, obviously we're going to be outside the European Union. That's the most important point. There is some indication of the intention around mobility contained within the political declaration that accompanied the withdrawal agreement at the end of last year. But that document, certainly in terms of mobility at least, is fairly slim, non-committal and ambiguous. The first point being, of course, that free movement no longer applies. Well, we know that. Mobility will be based on non-discrimination and full reciprocity. So whatever we offer the EU, and if it's agreed with them, then they should offer it the same to us in return. In terms of domestic laws, immigration will come under the control of our domestic legal structure. We'll no longer be signatories to the EU treaties. Immigration laws will be passed by Parliament, and that's part of the agreement or the discussion around sovereignty and the fact that the UK Parliament should be sovereign in these matters. The document does talk about considering conditions for entry and stay for purposes such as research, study, training and youth exchanges. It doesn't say any more than that. There's no detail on that. I'll talk a little bit later on about how I think that may operate in the future. The document talks about exploring the possibility to facilitate the crossing of borders for legitimate travel. Again, that's a fairly ambiguous sentence. I certainly don't think that there will be entry restrictions on EU citizens coming to the UK. There's no intention to impose what we call intention testing at the border, where an individual is asked questions by an immigration officer, and the immigration officer determines whether or not the person can be admitted under the immigration rules. I think that the same provisions that currently exist in relation to entry, such as the e-gates that you see at the airports, which simply require people to show their passports and they will be admitted, that will carry on. The reason for that, of course, is it would be logistically impossible to impose border controls of the type that we impose for non-EU nationals, simply because of the numbers of people who travel on a regular basis. But there will, however, be immigration controls on EU citizens. They'll be treated in the same way as non-EU citizens in the future. So whilst they may be able to move freely, in the sense that they'll be able to enter the UK freely, they'll be subject to conditions of stay, and they'll be required to be here subject to particular criteria set out in the immigration rules. And I'll talk a little bit later about how that's going to work. Most importantly, of course, they'll be subject to limited leave to remain. In other words, people from outside the UK will be granted permission to come in if they meet the requirements of the rules, but only for a limited period of time. And they'll be required then to apply for extensions of stay or indefinite leave to remain, etc., if they qualify for that. So the political declaration is fairly slim, and as a declaration, it's simply a statement of intent. It's not binding, doesn't have any legal force. So it's very much a work in progress, and the negotiations with the EU have now started. They started last week, in fact. Just a little bit of revision in terms of EU citizens who are currently in the UK. The basic principle being that any EU citizen who is here now is entitled to remain here as long as he or she is exercising what we call a treaty right by working, studying, being a retired person, etc., being self-employed. And such people are permitted to remain permanently. It's a little bit more complicated than that. Under EU law, if you exercise a treaty right in another member state for a 5-year period, you can apply for permanent residence. So 5 years is the lead-on period for permanent residence. The settlement scheme that you can see reference to there in that graphic says that people who are currently here, if they've been here for 5 years, they can apply for settlement. That's permanent residence under the digital scheme that the government introduced at the beginning of last year. We've technically left the EU, but we're in that central column period now up until the 31st of December 2020. And the agreement is that any EU national entering the UK during this implementation phase can exercise the same rights as they were permitted to do previously, and indeed stay on a permanent basis in the UK. So EU citizens entering the UK during 2020 can operate in exactly the same way as they have done in the past. So the cut-off date for protecting those rights is the 31st of December 2020. So if you're an EU citizen and you've been here for 5 years, you can apply for settled status. If you're an EU citizen and you haven't been here for 5 years, you can apply for what we call pre-settled status, and then you can remain until you've been here for 5 years and apply for settled status. So the population who benefit from that are those who are currently in the UK and those who enter the UK during this year. So that's why I think of the 1st of January 2021 as being the real Brexit day, because immigration control will change on that day, and EU citizens entering on that day or after that day will be treated in exactly the same way as non-EU citizens and will not benefit from the EU settlement scheme. The scheme, however, will remain open until the 30th of June 2021, a sort of grace period to enable people who haven't been able to apply previously to do so. So it's open for another year or so for EU citizens to apply under. So in terms of the way forward, the government has made a policy statement. It published a document on the 19th of February when it set out its intentions for a new immigration scheme. The overarching statement is that we intend to create a high-wage, high-skill, high-productivity economy with aims to treat EU and non-EU citizens equally, to reduce overall levels of migration, and to give priority to those with the highest skills and the greatest talents. And as I said before, that will be in the context of a points-based immigration system. So at the moment, we operate a dual immigration system, one set of arrangements for EU citizens, another set of arrangements for the rest of the world. In the future, there will be a one world immigration policy. And that's a consequence of the commitment to, as I said, end free movement and, quote unquote, take back control of our borders. The points-based system is described as a simple points-based system to be launched on the 1st of January 2021, part of a wider multi-year programme of change led by the Home Office to transform the operation of the border and the immigration system, and further reforms should be expected later in 2021. So the policy document that was published in February is really the headline. There's not a huge amount of detail. It only runs to, I think, about 12 pages. So there's a lot of meat to put on the bones of the future immigration system. And it is a work in progress in that there will be the new routes that will open, but there may very well be other routes that open in due course in 2021 and beyond, and they will be a response to the success or otherwise of the new points-based system, the needs of the economy, etc. Just a brief overview of phase one, which is the new points-based system. I think it will be still called Tier 2. As you know, many of you will know that we already have a 5-tier points-based system. Tier 2 is the scheme that that employers use to sponsor foreign nationals to work for them. It may have a different name. We'll see how it develops over the course of this year. But the first thing I would say about this points-based system is that Boris Johnson and others have been talking for quite a long time, even before the referendum, about a quote-unquote Australian-style points system. And the scheme that they've come up with is not an Australian-style system at all. And the reason why I say that is that the Australian system is what we would call a supply-driven system, where individuals can, if they succeed in obtaining the necessary points, can sponsor themselves, if you like, to go into Australia. They don't have to have a job offer in advance, and they can enter Australia and then look for work. That's a supply-driven system. The UK scheme that's being proposed is a demand-driven system based on employers' needs for skills. The Australian system was designed to build the population of Australia and to provide a supply route for skilled migrants, in many cases engineers and medical professionals, etc., teachers, people who had the skills that Australia needed in order to build its population and to build its economy. Whereas here in the UK, one of the overarching policies around immigration is and has been for quite some time about taking back control and controlling numbers. The overarching narrative of immigration policy for the last decade has been about reducing migration. Theresa May famously introduced her net migration target with the intention of reducing net migration to the tens of thousands annually. And she, of course, was in control of the immigration system, both as Home Secretary and Prime Minister, for most of the last decade, since 2010. It hasn't been successful as a policy, simply because it's not possible to control migration in the context of freedom of movement. Of course, now that we're stepping outside that system, it will be possible to have greater control of the numbers, but the scheme will also be driven by the needs of the economy and the needs of employers, etc. It'll be interesting to see whether there really is a drop in migration, maybe a drop in migration from the EU, but that may be counterbalanced by increased migration from the rest of the world. And there's some evidence to suggest that that would be the case, because since 2016 there has been a drop in EU citizens coming into the UK, potentially because they don't see it as quite such an attractive country to come to, given our decision to leave the European Union. But there has been a counterbalance and an increase in entry from non-EU citizens. So we'll have to see how that pans out. Some of the headlines of the new points-based system: phase one, suspending the cap. As you may be aware, there's currently a cap on the number of people who can be sponsored under what we call Tier 2 General of the points-based system. The number of certificates of sponsorship that are available to employers to assign to foreign nationals under the Tier 2 scheme. There's a cap on that, and that's allocated on a monthly basis. The decision has been reached to suspend that cap, so in theory, it will simply be demand-led, and there could be a significant increase potentially of sponsorship under this employer-led points-based system. Removing the resident labour market test, that's a very key and important point for employers, and I think a positive one. The resident labour market test is a requirement that employers show a genuine attempt to recruit from the local labour market before they assign a certificate of sponsorship to a foreign national. There are various exemptions to that, including, for example, intercompany transferees and jobs that are in the shortage occupation list. But as a general principle, employers have to advertise externally before they can offer a job and sponsor a foreign citizen to take it. That's being removed. So that should, in theory, make the scheme easier to navigate and use for employers. Sponsored migrants will have to obtain 70 points. I'll show you how that works in a second. The skill level will be at RQF3, which is basically around A level and is a slightly lower skill level than currently applies to the points-based system. A sponsor is required. So many more employers are going to have to engage with this scheme, and we do expect and anticipate an increase in the number of employers who will be applying for sponsor licenses over the next few months in anticipation of these changes as they come in at the beginning of next year. English language will be a requirement for foreign citizens coming to work here. And in some cases, it will be possible to trade points. In other words, if you're successful in getting sufficient points through one combination of criteria, then you don't have to obtain points in another area, or if you're unsuccessful in one route, potentially you could pick up points elsewhere. I'll talk in a second about how that might work. This is the breakdown of the points allocation. There are three areas which are what I would call core requirements. So you'll see that there's a column which mentions tradable, yes or no. The three areas that are non-tradable are having a job offer by an approved sponsor. That's a requirement. The job has to be at an appropriate skill level, RQF3 or above, and the individual migrant will be required to have sufficient understanding and ability to talk in English. The salary threshold is set at 25,600, which is just below, it's reasonably well below actually the 30,000 that applies under the Tier 2 scheme for Tier 2 General at the moment. That reflects the slightly lower skill level that's being applied. So if you have a salary offer for a skilled role at 25,600 or above, and you meet the first three criteria, then you will have the 70 points necessary to enter under the scheme. But you'll see also that it's possible to be paid slightly less than that, but the point allocation is lower as well. So if a job, for example, is paid at 20,480, between that and 23,039, then it is still possible to come in under the scheme, but you don't get any points for salary. But if you look at the criteria set out at the bottom, it's possible to pick up points elsewhere. So, for example, if it's a shortage occupation role, as defined by the Migration Advisory Committee, if it's a job that appears in their list of shortage occupations, then you can pick up 20 points for that, even though the salary is below the ordinary threshold of 25,600. Then equally, if you have a PhD in a technical subject, a STEM subject, you can pick up 20 points for that, even though perhaps the role may be less well paid. So it is possible, I should say, to earn less than 25,600, but that is considered to be the normal threshold. The focus of the scheme is that it is demand driven and led by employers, and that means that employers will have to comply, as they do now when they sponsor non-EU citizens, with the various compliance, record keeping and reporting obligations that are set out in their sponsor duties. So employers will continue to be under an obligation to in a sense, police the system, because this will be the main route of entry to the UK for skilled foreign citizens, and it's very much a compliance and enforcement scheme led by employers who are considered to be the beneficiaries of the scheme because they will have the skilled workers that they need. So there's no stepping away from the compliance framework that currently applies, and I'll talk in a future webinar about that, but employers do need to be ready to engage with this scheme and really to begin to understand it now if they're not already familiar with the Tier 2 scheme that's currently in operation. Phase 2, as I mentioned at the outset, this is a work in progress, and there will be other routes into the UK, or indeed there may be other routes into the UK in the future, depending on advice the government receives and the response to phase 1. In January of this year, a new scheme called Global Talent was opened, enabling the most highly skilled individuals who can achieve the required level of points to enter the UK without a job offer if they are endorsed by a relevant and competent body. And that's literally only opened recently. It's a little bit like the Tier 1 exceptional talent scheme that has been open up until now, and I'll talk about the requirements for it a little later on. But it's very new, and we're not sure yet how useful it's going to be. It's certainly well below a highly skilled migrant program, which is a sort of supply-driven system. There is some mention in the policy statement about the potential for a highly skilled migrant program or a Tier 1 general type of scheme in the future. The document says that we will explore proposals for this additional route to the points-based system with stakeholders in the coming year. They call it a broader unsponsored route, which will enable a small number of the most highly skilled to come without a job offer. But it's a very cautious statement in the policy document. It's non-committal, and it also talks about the scheme being capped and monitored during an implementation phase. Many of you will know, of course, that the UK has operated highly skilled entry schemes in the past. The HSMP scheme was introduced by the Blair government. That enabled individuals to obtain points according to various attributes, including educational background, previous work experience, income from skilled jobs in the past, etc., and individuals from outside the EU who could accrue the points were able to come into the UK and look for work or set themselves up in business. But that is absent from the new scheme, although this wording does suggest that the door is still open to some form of similar arrangement in the future. The Migration Advisory Committee, who recently published a report on these issues, found that individuals who had come into the UK under HSMP in the past, or Tier 1 General, which is the scheme that it became in 2008 when the points-based system was introduced, the MAC found that quite a significant number of people who came under those routes were not, in fact, working in highly skilled positions once they entered the UK. So there's there's some discussion about whether it is the most appropriate supply-driven route, but I think employers would be keen to see it as a future option for foreign citizens, simply because it will mean less engagement with compliance and less costs for employers as well. And I'll talk about the cost structure in a second. A couple of other routes that I just want to touch on, but I'm not going to dwell on. These were introduced last year, and these relate to entrepreneurs. There are schemes that enable foreign citizens to come either to start up a business or as innovators. They're very similar. The startup scheme allows individuals to establish a business in the UK. That person doesn't have to have prior experience, but they have to have an innovative, viable and scalable idea which is endorsed by an endorsing body. And there's a list of endorsing bodies that has been published by government. It's not a route that leads to indefinite leave to remain, but you can, if you're successful under this route, progress into the next category, which is the innovator category. And that's for people who also want to establish a business in the UK, but it's for more experienced business people. So more experienced business people can come under this route without first coming under the startup. Again, it has to be endorsed by an endorsing body. Again, you have to have an innovative, viable and scalable idea as approved by that endorsing body. So in a sense, government is outsourcing the decision-making process for deciding who can come to the UK as an entrepreneur to these endorsing bodies. There is some funding required for innovators, but it's a category that can lead to permanent residence, indefinite leave to remain after 3 years. Most of the endorsing bodies are either in the tech sector or operate schemes that require investment from that endorsing body, so they see it as a commercial opportunity for that endorsing body. So many of these bodies have accelerator programs that the individual migrant is required to participate in before they can be sponsored. There's been very disappointing take-up under the innovator and startup schemes, really just handfuls of applications. And so it's generally considered by practitioners and people who work in this immigration world as not a particularly successful scheme. And the thought is that the government should come up with a more appropriate route for entrepreneurs if we are to encourage inward investment from overseas and to encourage the best entrepreneurs to come here to set up their businesses. The Global Talent Scheme that I mentioned, as I said, it's only very recently opened, so it's far too early to decide whether it's a success or not. But it's for leaders in their field, or people with the potential to become leaders in their field, in the context of science, engineering, medicine, humanities, digital technology, arts and culture. And again, you have to have an endorsement either from one of these organisations that are pretty well known: the Royal Society, the British Academy, the Royal Society of Engineering, Tech Nation, Arts Council England, and UK Research and Innovation. So this is a work in progress. It's a new scheme, and over the next few months we'll see how successful it is. But I don't anticipate that it's a scheme that will bring in large numbers of migrants into the UK in the way that a full, highly skilled migrant supply-driven scheme might. So how can you plan for all of these changes? Employers need to really be thinking about this now, because 2020 will go very quickly. The new scheme will be on us very soon, and so we all need to start thinking about how we're going to work towards the 1st of January 2021. So there are three stages to this, I would suggest. Businesses should start their workforce planning now, if they can, for hires after this year. And that should include considering the additional costs that may apply to employing non-British workers, because the resident labour market in the future will be the United Kingdom. That's the whole purpose of, or one of the purposes of, Brexit. whereas up until now the resident labour market has been the United Kingdom and the European Union. Many of you know that there are lots of costs associated with sponsoring foreign workers. They include the NHS surcharge, the immigration skills charge, and the transactional fees that apply to making immigration applications. So there's potential for budgets to have to be expanded in the context of sponsoring foreign workers. For employers who do not have a sponsor license at the moment, it's advisable to gain an understanding of how the sponsor license scheme works, currently under Tier 2, as I say, and also to apply for a sponsor license if you think there's a reasonable degree of likelihood that you're going to need to sponsor somebody from outside the United Kingdom in the future. And many employers will want to do that in the future. And also now, and I imagine many of you will have been doing this up until now as well, communicate to European citizens who are currently working for you about the changes, about the EU settlement scheme, to encourage people to apply under that scheme and obtain their settled status. It's anticipated that the government will publish further and more detailed guidance on how the new points-based system will work over the coming weeks and months, and it may very well be introduced before the end of the year, so that employers and others can gain an understanding of how it's going to work and be fully prepared for the 1st of January. So certainly for September of this year, I would advise employers to have an understanding of how the new immigration system is going to work, when the various schemes are going to be opened, etc. To start planning for applications post-January 2021, and if you work with immigration suppliers, to talk to them and to gain an understanding from them about the implications in terms of visa processing, etc., compliance, and all of the other things that I've discussed. If possible, think about bringing EU citizens into the UK during 2020, so that you can continue to benefit under the freedom of movement regime during this transition period. And also, of course, for EU citizens, if they come in this year, they will be able to benefit from the EU settlement scheme. That applies to anybody coming in this year. So in theory, you could come in on the 31st of December to take a job and still benefit from the EU settlement scheme. And then, of course, the launch date will be January 2021, 1st of January, necessary to ensure that all European citizens who are in the UK before that date have applied or intend to apply under the settlement scheme by the 30th of June 2021. Ensure that you have robust compliance and monitoring procedures and systems in place for visa holders, for non-EU and EU, because it'll be a one world system in the future. And really just to keep up to date with immigration changes, because I anticipate that there'll be lots of further announcements during the course of this year, and much more detailed guidance will be published in respect of the operation of the new employer-led points-based system. There may also, I suspect, be an influx of EU citizens coming into the UK before this cut-off point. People who want to benefit from the settlement scheme will see the urgency to actually make the move before the end of this year, whereas perhaps otherwise they may have done it at a later date. It'll be interesting to see whether there is such an influx in the last 2-3 months, Q4 of 2020. There are quite a lot of positives, I think, for employers coming out of this new policy. I've already mentioned the removal of the resident labour market test. That's a really crucial one, and I think employers will welcome it because, apart from anything else, the resident labour market test takes up employer time because advertising is done over a 1 month period. The fact that the quota for certificates of sponsorship will no longer apply again is a positive. Employers won't have to juggle the monthly limit on restricted certificates of sponsorship. Overall, the indication is that the new scheme will be more liberal and more open than the previous Tier 2 scheme. And it strikes me as being something of a curiosity or an irony that in quote unquote taking back control of immigration, the government is aiming to introduce a more liberal immigration policy. You see that reflected in the lower skills threshold, the removal of the resident labour market test, the lower salary threshold, the tradable points position, and of course, potentially employers will be able to use this scheme as an alternative to intra-company transfers because the resident labour market test will no longer apply. And therefore, people coming under this scheme will not be subject to cooling off periods after they leave when they can't apply to re-enter the UK. And they will also benefit from a route to settlement. So we may see more applications for indefinite leave to remain in future years. So a lot of this is really about dismantling many of the reforms that Theresa May introduced during her time in office, when she introduced quotas and caps and targets, etc. Those are falling away, and after 10 years of constraint around the immigration scheme, we're seeing a much more open system in the future, potentially, which, as I say, is slightly ironic given the overarching conversation that's been taking place about taking back control and reducing migration numbers, etc. There are also some pretty significant negatives that employers need to bear in mind. Most importantly, much higher costs because of the various taxes and transactional fees that apply to immigration matters, and the fact that more people will be subject to the scheme, more people will be captured by the sponsorship scheme because freedom of movement won't be available to a very significant population of people who may want to come to the UK. I noted a few days ago in a 2018 document from government about the future immigration arrangements, they said that our aim is to keep reporting requirements and upfront costs for employers to an absolute minimum. Well, this scheme does the opposite to that because so much of it comes in the context of the compliance scheme for employers. And of course, as I've said, there are very significant costs on an individual basis for every type of application. So if that is part of the purpose of the scheme, it certainly doesn't succeed. There are questions over the scheme in terms of whether the Home Office really has the capacity to introduce a scheme like this over the course of 10 months. Boris Johnson has said that the government will not seek an extension to the negotiation period, which theoretically was open to them with the EU. He's been very clear that that will not happen, that our departure at the end of the transition period will take place at the end of this year. So there's a question about whether the Home Office really has the resources to meet the demands that this scheme will inevitably impose on the Home Office. It's necessary to introduce legislation, to train Home Office staff, to retrain them, to launch the systems, to make sure that the various digital systems, etc., are able to adapt to a potentially much larger population of people who will be applying under them. Other considerations within the policy, there's no new route for low-skilled workers, and that's very significant. I'm thinking about sectors of the economy such as care workers, construction workers, hospitality, etc. Particularly if you look at construction in the context of all of the famous infrastructure projects that this government intends to pursue, such as HS2, Northern Transport Links, airport capacity, whether that's at Heathrow or elsewhere. All of those schemes are going to need workers, and there's a question over whether we have sufficient numbers of such workers here in the UK. So potentially construction workers will have to be sponsored if they meet the requirements of the new points-based system. As a sort of tangential issue to that, many construction workers operate currently on a self-employed basis. That's the way the industry tends to work, is that people work for themselves and then will take project jobs with various builders and other construction schemes. There's no route for the self-employed in this points-based system context. So it's going to be interesting to see how the construction sector will adapt to that. The care sector is a very important topic at the moment, whether we have sufficient numbers of people, particularly in the context of social care. And it's not clear that social care workers will qualify to be sponsored under the points-based system, and indeed they may also be, in many cases, self-employed individuals. And then the hospitality sector is very significantly resourced by young EU citizens, certainly in London, and whether there will be a sufficient supply of workers in the vast hospitality sector in the UK remains an open question. In that context, I've mentioned Tier 5 youth mobility. I think there may be the possibility that that scheme, which currently works for a number of countries on a reciprocal basis around the world for young people to come here to work for up to 2 years, could potentially be expanded to include EU citizens, young EU citizens coming, let's say, for up to 2 years to work. That may help certainly the hospitality sector, and it may be something that the government would be keen to agree as part of a conversation with the European Union, so that our young people can continue to benefit from travelling into Europe for periods of time to work and gain life experience in other countries. That's something that will potentially be lost as a consequence of Brexit. The previous government, the May government, had plans for a 1-year visa allowing unskilled work as part of a transitional set of arrangements, but that plan has not been adopted by the new Johnson-led government. So I think there is potential for possibly for expansion of the youth mobility scheme to meet some of those sectoral requirements. Just a couple of other ancillary points. EU students will be covered by the points-based system in the same way as non-EU citizens. That comes under Tier 4 of the points-based system. So points-based system currently. So EU students will have to obtain what we call certificates of acceptance for studies in the future and be sponsored by their educational establishments. I've mentioned entry to the UK already, the e-gates, which is a very successful arrangement whereby people, either British citizens or currently EU citizens and citizens from some other countries, can simply present their passports to a machine at the airport. They will remain open because that enables the flow of people. Doesn't mean to say, of course, that the consequence of that is that people are admitted for an indefinite period to do whatever they want. They'll still be subject to immigration requirements, rules, and periods of leave to remain, but there potentially will be electronic schemes that will enable that to happen, and EU citizens potentially may have to apply for an e-visa or an e-permission before they come into the UK, in the way that British citizens have to do when they go to various countries such as India, such as the United States, etc. At the moment, costs and levies will apply to EU in the same way as non-EU. I've already talked about the various costs, and the UK is a very expensive country for immigration. It's one of the most expensive in the world because of the NHS surcharge and the immigration skills charge and the transactional fees that the Home Office applies to immigration. There are two purposes for that, the government would argue. One is to provide for tax payments into our public sector for people who come in and benefit from migrating into the UK, and for employers who benefit from skilled workers from overseas. And the other is so that the Home Office pays for itself rather than being funded by the general population. The final point I'll just make here quickly is in relation to Ireland. Irish citizens have a special status in the UK because of the common travel area. They will continue to be able to come here freely and work here freely. These arrangements have been in place for many years before our membership of the European Union, and also Irish citizens do not have to apply under the EU settlement scheme. So that's some good news, certainly for Irish citizens. Just one final point before I go. In terms of British citizens travelling to the European Union, it's going to be a very different situation next year. For decades, British citizens have been used to travelling freely to France, Germany, Greece, Spain, Italy, wherever, without being required to obtain visas, without being required to give reasons for their intentions on arrival, etc. All of that will fall away next year, and employers many of whom send their workers into the European Union must be ready for what will be a very significant change in arrangements. The anticipation is that there will be visa-free business travel. That simply means you don't need to apply to a consulate for a visa in advance. But people travelling into Europe will have to meet the visitor rules of the country that they are entering. And most importantly, people intending to undertake work-related activities will only be able to undertake activities that are permitted under the domestic immigration rules of that country. So the question that almost invariably will apply when going in to undertake a work-related activity in Europe will be whether or not that is productive work that requires a work permit in that country, or whether the activities are permissible to the extent that a business visit is allowed, albeit for potentially a relatively short period of up to 90 days. So that will require significant thought by employers who are currently used to sending people all around Europe. It's going to be a major change in the way we operate in the context of our location in the world. We won't simply be able to travel into Europe as freely as we did before. And note that the Schengen area time limits mean that people who are not members, citizens of the European Union, are limited to 90 days in any 180-day period physically present in the Schengen area. So the limits will be much more significant than has hitherto been the case. There is an anticipation excuse me, that there'll be an electronic visa waiver system. So if, as a British citizen, I want to go to France, I'll have to go online and provide some details and give information about my intention to travel, and then I'll get a prior approval electronically. But that, again, is significantly more complicated than the current position where I can simply travel freely into France. And bear in mind, of course, that if a person does need a work permit for an EU country, that application will have to be made to that EU country. There are different arrangements in each EU member state for non-EU citizens wanting to work there, and it can take, in some instances, between 3 to 6 months to obtain a work permit for these countries. And that requires considerable preparation, prior planning, etc. And so employers are encouraged to start thinking about these issues now in terms of going into Europe, as well as all of the issues that I've outlined in terms of people coming into the UK to work in the future. I think I'll end it there. It's probably enough material for one webinar. If you have any questions, please do send them to me. You'll see my email address there, ben.sheldrick@mcgrath.co.uk. I'll be very happy to answer any questions that you may have about any of the above, or give me a call. You can see my telephone number is there as well. And we will be presenting further webinars and other communications in the future as the situation develops and as we start moving towards the 1st of January 2021. Thank you very much for your time today.